The Manhattan grand jury did not meet yesterday to hear evidence in the hush money case against former President Donald Trump, and they will reconvene on Monday. But a decision on charges is expected any day now. Joining us live to discuss the possible indictment and charges, former prosecutor in New York County District Attorney's Office and criminal defense lawyer A. Scott Bolden. Thank you so much for joining us, Scott.
Thank you for having me.
So first on timing here, we all know former President Trump had predicted on social media that he would be arrested on Tuesday. It's now Thursday. That has not happened. What do we know right now about where things stand here?
Well, the grand jury is reconvening today. We know that. You know, the grand jury in New York doesn't convene every day, if you will. And there's a time frame for when that grand jury runs out and another grand jury would pick it up. So we simply don't know. Following, like the media has done, following Donald Trump's time is not following much at all, because all of this is being controlled by Alvin Bragg, the lead prosecutor or the district attorney in New York County. And so we'll just have to wait and see. Once they take that vote goes to the grand jury judge, and it'll be up to the grand jury judge as to whether he allows them to publicly announce it, whether he sits on it for a couple of days. So we just don't know.
So what do you know, or what have you gleaned about the strategies of the prosecutor here, as well as any strategies from former President Trump's defense team?
Well, the district attorney holds all the cards. They drive the narrative. That is, they have the burden of proof. They can have this grand jury sit and consider all the facts and determine what charges they're going to bring and present to the grand jury. Remember, the defense has put in at least one witness, which is unusual. Usually it's just the government, which is why a lot of critics of the grand jury say a grand jury will indict a ham sandwich. On the defense side, for Donald Trump, it is an issue as to what witnesses he's put in or will put in, because the government has allowed him to do that, one. Secondly, their best argument is that these charges in connection to Stormy Daniels took place over 5 years ago. And the statute of limitations, I think, is 5 years in New York for these business records manipulation. And so, if so, look for a series of motions from the defense, if he's indicted, as to dismiss the indictment for the statute of limitations period. That being said, Alvin Bragg would be smart to put in a racketeering charge or a conspiracy charge that would help them get around the statute of limitations, because it would be an ongoing criminal enterprise, or the arguments along those lines.
And would that change? I mean, we know currently we're talking about misdemeanor charges here, but could any of that turn this into felony charges?
Well, conspiracy and racketeering or any other financial crimes would usually be considered felonies. And you know, the misdemeanor can go to a felony level if it was done, the altering of business records, if it was done in furtherance of another crime, whether it was a state campaign finance crime or even a federal campaign finance crime. They'd need a bridge to get there. And it'll be interesting in the indictment to see how the DA does that. But in the end, I suspect that there will be several charges, not just the one regarding Stormy Daniels and, you know, altering the business records to make it look like a legal fee payment. There's got to be more there. Because remember, you've got the Georgia case, and then you've got the federal case, which are far more serious charges and far more serious investigations going on.
Right. Scott Bolden, criminal defense attorney. Thank you so much for your time and your insights. We appreciate it.
Thank you.